last year, he was appointed as the 11th substantive Vice Chancellor of this university. Professor Edoba Omoege, Senior Advocate. And of course, the first legal man to handle this very unique position of Vice Chancellor of the University of Benin. And if we also follow the trajectory in the last 3 or 4 inaugural lectures, it has been lawyers all the way. I'm not sure they are going to hand over the baton very soon. So it is on this note that I also want to present to us the man of tradition, but also a distinguished scholar, the Deputy Vice Chancellor Academic, who is standing in for the Vice Chancellor today, Professor Victor Oge-Igbiwe Neweka, Deputy Vice Chancellor Academic, standing for Vice Chancellor. Let's also put our hands together for Professor Bunyami Ayinde, the Deputy Vice Chancellor, Ekenwa Campus. We have with us today the representative of the bursar of this university. The bursar is Mr. Sifo, a distinguished fellow of, but he has so many things to attend to in Abuja, and is being represented today by a very distinguished accountant too, a senior deputy bursar in the bursary of this university, Zanero. And of course, a very distinguished scholar, this time in the library, and immediate past HOD of Library Science Department of a sister university. He has served as university librarian of another university before. She has transversed everywhere, but she has been arrested to the University of Benin as her own university librarian. Professor Mrs. J. Abba. We have on this other side of the divide a college that is being projected to go to greater heights. If I look at his face very well, it was in Europe some days ago to project this particular college, where we want to put together everybody wants to acquire University of Benin postgraduate degree certificates with proper training. Professor David Izeko is the Provost College of Postgraduate Studies. We have also the #1 student of this university. He's a distinguished professor and is the Dean of Student Affairs, Professor Fred Ekaisi. We have the host dean today. The inaugural lecturer is the host. Is the lecturer giving lecture today, but that position must not be vacant so that we can follow law duly. But he has one of his teachers, the man we have been seeing when I was small, who were always looking to the television then, NTA. And he was a member of the Hotel de Jordan of those old days. Professor Richard Ijubo is standing in for him. The Faculty of Law. Of course, we have one of the tallest in the Vice Chancellor's entourage, Professor C.O. Emokal, the Dean Faculty of Agriculture. Standing in for the Dean Faculty of Arts, Professor E.B. Adeleke. The Dean School of Basic Clinical Sciences, Professor V.J. Ekamel. The Dean School of Basic Medical Sciences, Professor H.B. Osadolo. And we have the potent Dean Faculty of Communication and Media Studies being represented here today by another distinguished professor from that field of study, Professor F.P. Olise. We have with us the Dean Faculty of Education, obviously the most do we say the elderly in office? Yes, if it's allowed. because I'm before the lawyers. So I should count my words very well before pronouncing. It's about the longest serving dean of any faculty at this particular moment. Professor Kingsley Omo-Ogiwa. The Dean Faculty of Engineering is ably represented here today by Professor O.O. Igodao. And we have also the Dean Faculty of Environmental Sciences, Professor Egiato Irugbe Raphael. And we have the Dean Faculty of Life Sciences, Professor T.O.T. Imobe. The Dean School of Medicine is ably represented here today. Let me just remark that the Dean of Medicine has been so busy working with the DVC academic on assessment of academic staff for promotion this year. So maybe he's still trying to round up. Professor A.I.O.B. is standing in for the Dean School of Medicine. The Dean Faculty of Management Sciences, Professor Mrs. E.I. Ebairo Osage. And of course, we have the Potent Dean Faculty of Nursing, Professor, not Mrs., Professor Man, Professor Mr., if it's possible, F.U. Okafor. Please, let's give him a round of applause. He's a man doing very well in the world of women. The Potent Dean Faculty of Optometry is Dr. K.N. BAZUAYE that is standing in for the Potent Dean. Dr. K.N. BAZUAYE. So let's give him a round of applause. And also we have with us the Dean Faculty of Physical Sciences, Professor E.O. Ayowuni. And we have also the Potent Dean Faculty of Science, Laboratory Technology, Dr. K. Ojiaga. We have with us the Dean Faculty of Vocational and Technical Education, Professor E.E. Uko Aviomo. The Director Center for Gender Studies, Professor Mrs. Lucy A. Okupon. We have the Director Center for Distance Learning Program, Professor Mrs. Era Kweme is also here with us. Let's give her a round of applause. Blessed are those who have not seen yet believe. She is very much there. We have the Director Center for Entrepreneurship Development, Professor B.O. Edegbai. And we also have the Director Intellectual Property and Technology Transfer Office, that's IPTTO, Professor Solomon E. Amonio. And of course, we have the Director Center for Sustainable Development Goals, SDG, Professor Mrs. F.I. Okunboa. Director of JUPEB, that's Joint University Program, JUPEB, one of the pre-degree programs of this university, and formerly a warlord. He doesn't want to be called warlord. He was leader of ASU. I was very combative none of his days. Some of us outside this place were hearing about him then. Professor K.O. Ilavari is the Director of JUPEB. Let's give him a round of applause, please. We have the Director of University Advancement and Alumni Relations, a former orator of this university, Professor Eddie Eragwe. We have with us today, too, in the Vice Chancellor Central, the Director, Advanced Digital Engineering Center, Professor R.S. Ebojaye. And of course, we have the Director, Institute of Child Health from the College of Medical Sciences, Professor Mrs. Aebo Sado. And we have also the Director of Research, Innovation and Development, DRID, we call that center, and a distinguished woman in law practice too, and a scholar of excellence, Professor Mrs. Ngozi Finet Oluigwe. At could see that you are being partial. When I was calling you that you didn't. I think you should use justice to balance the whole thing as we see the symbol of balance. We have with us the Director of Student Guidance and Counseling, Professor Mrs. O.N. Ahie. We have the Director of General Studies Center of this university, Professor N. Ohomba. The Director of African Center for Mushroom Research and Technological Innovations, Professor E.O. Akpaja. The Director Center for Continuing Legal Education, Professor Dennis Odigye, is one of us. And we have a distinguished engineer, the Director of University of Benin Training Center. We call it UBIT, Professor S.G. Iyeke. And we have the Director of Step B program of this university, Professor Mrs. N. Kayode Ojo. We have the Director of NEL Fund. Those who cannot really get their school fees through or school charges, you go to his office. He used to be in Student Affairs and is now the Director of NEL Fund, Professor E.E. Mariagwe. And we have the Acting Director, Institute of Education, Dr. K. Imaswe. And then we have the Acting Director, Institute of Public Administration and Health Services Management, Dr. John Osagai. And we shouldn't be tired, we should continue, we still have more. Director, Center for Educational Technology, Dr. Mrs. B.N. Agawa. We have with us the Director of Consultancy Services Unit, University of Benin, Professor R.O. Edopia. The Deputy Registrar, Senate Matters, who led the Vice Chancellor Central, Mrs. C.I. Egato, is also here too. Distinguished ladies and gentlemen, please allow us to have this long list, because the man who is giving the lecture today is a distinguished scholar, and then he has contributed so much to the development of this university, and the Faculty of Law is being respected, so all of us must be present. It is on this note that I want to call on the acting Vice Chancellor to please present the Vice Chancellor's address.
Distinguished ladies and gentlemen, I join the PRO to welcome you to the University of Benin. Our dear Vice Chancellor, Professor Edoba Bracha SAN, has other official engagements at about this time outside Benin. He has therefore asked me to come and read the address, and introduce the lecturer for today, Professor Bright BAZUAYE, on the occasion of the 353rd in the inaugural lecture series of the University of Benin, delivered today, Thursday, 9th October 2025, at this Akin Deco Auditorium of the University of Benin. Principal officers of the university, the Provost College of Postgraduate Studies, Provost College of Medical Sciences, the Deans of Faculties, Directors of Institutes and Centers, members of Council here present, Professors Emeriti and members of Senate here present, my lords, spiritual and temporal, staff and students, distinguished invited guests and friends of the university, gentlemen of the press, distinguished ladies and gentlemen, it is with delight I welcome you all to the 353rd in the inaugural lecture series of the University of Benin. Today's lecture is the third to be delivered in the Department of Jurisprudence and International Law, 13th in the Faculty of Law, and 24th to be delivered in my tenure as the Vice Chancellor of this great institution. Ladies and gentlemen, it is my pleasure to introduce our lecturer for today. He is Professor BAZUAYE. The title of his lecture is The Tortoise Beneath, Jurisprudential Ambivalence in the Foundations of Law and Legitimacy. Professor BAZUAYE was born 22nd February 1966 in Benin City to Mr. BAZUAYE of BAZUAYE Emery family of Ugbagwe, now Ugbagwe quarters, and Mrs. Helene BAZUAYE Niobareti of Ogbilaka quarters, both in Benin City. He attended the Daken Primary School, Selo, Benin City, where he obtained his first school living certificate in 1979. He had his secondary education at Edukpolo Grammar School. Edukpolo Grammar School, Benin City, where he obtained his West African School certificate in 1984. Thereafter, he gained admission into the Bende State University, Epoma, now Ambusali University, to study law and graduated with a Bachelor of Laws degree, LLB, in 1990. Professor BAZUAYE proceeded to the Nigerian Law School, Lagos, where he obtained his professional qualification in law and was called to bar in 1991. He did his one-year mandatory national youth service in Ministry of Justice, Ogoja, Cross River State, from 1991 to 1992. In his quest for more knowledge, Professor BAZUAYE obtained the Master of Law LLB degree in 2001 and PhD Law in 2015, both from the University of Benin. Professor BAZUAYE worked as a barrister and solicitor of the Supreme Court of Nigeria at Chief H.O. Ogod and Co. SAN, Benin City, 1993 to 1995. He joined the services of the University of Benin on the 29th day of November 1995 as an assistant lecturer in the year 2001 in the Department of Jurisprudence and International Law, and rose through the ranks to the position of professor in 2018. Professor BAZUAYE has held some administrative positions within and outside the university. He was member Central Examination Committee, UNIBEN, 1999 to 2001. Lecturer in charge, Department of Jurisprudence and International Law, UNIBEN, 2006 to 2007. Acting head of department, Jurisprudence and International Law, University of Benin, 2009 to 2013. And again, in 2013 2018 to 2019. Member Guidance and Counseling Center, University of Benin, 2013 to 2015. Assistant Dean, Faculty of Law, 2014 to 2017. Member Task Force Water Factory, University of Benin, 2017. Member Senior Staff Disciplinary Committee, University of Benin, 2014 to 2017. Member Ceremonials Committee, University of Benin, 2014 to 2019. Member Procurement Planning Committee, University of Benin, 2015 to 2019. Head of Department Jurisprudence and International Law, University of Benin, 2019 to 2020, 2023 to 2025. Member Uniben Prizes Scholarship and Endowment Awards Committee, 2024 to date. Member Affiliation Committee for the National Institute of Legislative and Democratic Studies, NILS, Abuja, 2025 to date. Professor BAZUAYE is a member and fellow of some professional bodies and associations such as Nigeria Bar Association, NBA, Africa Bar Association, Nigeria Association of Law Teachers, International Law Association. He has successfully supervised 3 PhD theses, over 50 master's theses, and numerous undergraduate students' projects. He has over 50 publications comprising chapters in books and articles in peer-reviewed journals. He has served as a member of the Nigerian University's he has served in NUC accreditation committee, accreditation teams, and as external examiner, assessor, resource person to many universities. He is a reviewer of several academic journals and has attended several local, national, and international symposia, seminars, and conferences. Professor BAZUAYE was the coordinator of the university's legal unit from 2013 to 2019. And again, from 2014 to 2018, he was also the director of legal services of the University of Benin from 2019 to 2022. He was the Dean, Faculty of Law, Kola DC University, Ibadan, from 2021 to 2022. And again elected the Dean of Faculty of Law, University of Benin, January 2025 to date. Professor BAZUAYE hobbies include reading, watching football, and he likes to travel. He is a devout Christian and married to Mrs. Joy Omoze BAZUAYE of the Department of Curriculum and Instruction Technology, Faculty of Education, University of Benin. And the union is blessed with 4 children. Ladies and gentlemen, it is my pleasure to invite Professor Bright BAZUAYE to deliver his
I'll stand on the protocol ably established by our PRO. My Vice Chancellor, ably represented by DVC Accounts, Professor Gbeneweka. It is a profound honor to stand before this assembly to disentangle what lies at the very heart of legal philosophy and practice. Before I take a plunge into my philosophical odyssey, allow me to begin with a story. It is the story of millions of persons. It is a simple story, but heavy with meaning. It is about a father who took his children on a slow drive around this university. At some point in the journey, he pointed to some buildings and said, almost as if speaking into emptiness, if you take your studies seriously, one day you'll be here. It was a seed sown in passing, but the children remembered. Years turned, seasons changed, and those quiet words took root. I know this story very well because I'm in it. I was one of those children, and today I stand here not only as a professor of law in this great university, but as the owner of the truth my father spoke and the bearer of the memory that brought me here. So how do I make sense of this moment of standing here delivering an inaugural lecture at this point in my life? Perhaps I need to say something about my name. The first is Bright, a name my parents choose, I imagine with intention, hope, ambition, maybe even prayer. But I have another name, and my wife is surprised that they are coming up now. It's Ideyoma. The name, I didn't see anybody using that name, so I discarded it, but it's still there in my birth certificate. At the university, somewhere along the line, I stopped using the name, which simply means to fall into good. And the last is Nawokere, meaning who says something is left. And when expressed fully, it means Nawokere or Kere or Igbe, meaning who says something is left, it is up to the person. These are modern names. They are suppositions, aspirations, and philosophical claims. And they hold meaning for today's inaugural lecture. Because in law, too, we wonder about what is left. What holds it all up? And on what do we build? And this brings to mind a well-known apocryphal anecdote about a distinguished philosopher who travels widely to give lectures on the origins of the earth and its place in the universe. And this is where the issue of the turtle, or turtles beneath, comes into play. You'll be relieved to know that I know what my wife has prepared as little for refreshment, and turtles are not in it, in the menu. But turtles will be served philosophically today. This philosopher, at a point delivering his lecture, a member of the audience interrupts to offer a correction. The earth, he insists, rests on the back of a giant turtle. Curious, the philosopher asks, what does the turtle stand on? The person replies without hesitation, another turtle. The philosopher, sensing an opportunity to showcase his intelligence, presses on, and what supports that turtle? With an air of amused certainty, the person responds, it is turtles all the way down. This anecdote holds surprising significance today. It is a profound metaphor for the law itself. Because for every statute, every institution, every judgment, we ask, What gives it authority? More often than not, we find ourselves in a kind of infinite regress. It is one justification pointing to another with no final, incontestable ground. These are the turtles beneath our legal foundations. This is not just theoretical. It plays out in real situations, in claims of diplomatic and sovereign immunity, universal jurisdiction, in the daily struggles of people seeking justice. Today, we will journey through some layers of justifications, from Sophocles' Antigone to the Pelusian explorers to other legal issues, and then contemplate on what does the law stand, and what do we do when the turtles beneath are questionable. Through these lenses, we will confront law's ambivalence and legitimacy in a world where institutions are strained and the search for certainty in law seems ever more elusive. So I ask you, my audience, to be my Ideyoma, to fall into good. Be open, gracious, receptive, and forgiving of my hubris. My promise is that if we journey well together, if we think critically and imagine boldly, we may end with more than understanding. We may be able to affirm in one voice, no okay, Introduction. There are positions in law, knowingly or not, they rest on certain metaphysical, moral, and philosophical assumptions. Assumptions that are often deeply contested. BAZUAYE 2024. When these assumptions play out, the temptation is to caricature opposing views as ideological, biased, or even confused. In multicultural and multi-religious society like ours, we need to examine the assumptions of others, but also critically reflect on our own. My Vice Chancellor, sir, the task of jurisprudence is to uncover the turtles beneath, the assumptions upon which law rests, to question them, to revise them, and occasionally to reaffirm them with deeper clarity. In this inaugural lecture, I will interrogate the premises beneath the law, in the decisions we criticize, and in those we support. So let's look at the nature of law. Some are of the view that law is valid by virtue of its form if made through proper channels, procedures, and enforced by institutions. So legality, they see it as about structure. Others, law cannot be understood or obeyed unless it is tied to justice, however difficult that may be to define. And they simply conclude that an unjust law is no law at all. The tension between what is lawful and what is good is not new. Let's look at the force of law. Law compels us to pay taxes. Taxes that we may dislike, follow rules we find arbitrary, and accept outcomes we consider unjust. But there's something else about law. Act 1994 says law also empowers. It enables us to establish contracts, establish corporations, or write wills. In fact, law is the vocabulary of our rights and duties. But what about sanctions? Because most persons believe that the hallmark of law, from the Austinian standpoint, is that there must be what? Sanctions. But we know law can imprison, impoverish. It can even lead to the imposition of capital punishment on an offender. This gives law its formal legitimacy, but it also invites moral scrutiny. The power of law raises deep philosophical concerns. If we cannot agree on the values that law must serve, then its coercive authority becomes increasingly fragile. People may just obey the law out of fear, not out of respect. The danger, when obedience is frail, legitimacy itself begins to erode. BAZUAYE 2025. This takes me to Sophocles, Antigone, and Longfula's case of the Pelusian explorers. I know my jurisprudence students are here. They both dramatize the fourth lines where law, morality, and justice collide. Let's take Antigone. Antigone defied the king. The king is a sovereign, and we know that any law emanating from the sovereign must be what? Obeyed. The sovereign decreed that Polynices, his brother, branded a traitor, must not be buried. Antigone did not think Creon's decree was strong enough to overrule the unwritten or unalterable laws of God. Ordinarily, Antigone is ready to obey a law she believes to be eternal and universal. One she believes that Creon cannot create or abolish. The tragedy lies not just in the deaths. Antigone died, Creon's wife died, Creon's son also died. The son was yet another argues the statute must be interpreted with common sense and moral purpose. To punish the survivors would be to mock justice. But in the end, they were sentenced to death because of legal positivism, because that is what the law provides. Okay. Who is the, okay. Okay. What are the lessons from both? Don't worry. Law is not self-sufficient. It must be interpreted, defended, and lived always within a context of moral diversity and human complexity. Neither Sophocles nor Fuller gives us certainty. But what we know in our world is that for every crayon, there is an category. For every statute, a circumstance it does not fit. For every legal principle, a human cost. This is the burden of jurisprudence, to recognize that law may never have a final foundation, but that our ongoing struggle to justify it, to make it humane, and to keep it open to reason is what gives it life. So this takes us to the real life situation. Let's go to the real world and leave the fictional world. And we are going to look at three cases. Three cases here will demonstrate that. And the first has to do with the case of Palmer. Palmer killed his grandfather. Because to get his portion as far as the will was concerned, killed his grandfather to secure the inheritance promised to him in a will. And the aspect here was that the New York's probate law, the will was valid irrespective of what Palmer had done, because Palmer was the named beneficiary, but the court refused to enforce the will. The majority of the statutes itself said nothing about murderers inheriting, and such that it was not obvious why Palmer should be denied inheritance. But this is where tortoise begin to shift. A legal positivist like Justice Gray in dissent was of the view that the only business of a judge is to interpret the law, not to rewrite it. The majority's decision implied that the law is never just a closed system of rules. It draws on extra legal norms, even when those norms are not written into the statute. Reeves exposes an unavoidable dilemma. Either law must be flexible enough to accommodate morality, or it must risk legitimizing injustice when morality diverges from the written law. We also have the case of Gillick versus West Norfolk and West Birch Area Health Authority. Okay. Here, what was an issue was autonomy, childhood, and moral authority. And the question was, can a doctor lawfully give contraceptive advice to a girl under 16 without parental consent? This was a question of statutory interpretation and professional discretion. But beneath it lay deeper questions. Who possesses moral agency and when? Do parents have an unassailable right to guide their children's moral development, or does the state, through its medical professionals, have a duty to respect a minor's involving autonomy? The House of Lords ruled a girl under 16 years could in some cases consent to medical treatment without parental knowledge or approval, affirming, as it were, that capacity, not age, determines authority. But what makes this case so philosophically charged was not the ruling itself, but the collision of worldviews it revealed. Osadolo and BAZUAYE 2001. One side saw parental authority as divinely or naturally conferred and unchanging, while the other saw the minor as an emerging right holder capable of moral decision. Let's look at the situation in Roe versus Wade. This was a precedent for 50 years, which has not been recently overruled in Dawes versus Jackson. And the case borders on a woman's right to terminate a pregnancy, at least within certain limits. When that decision was reached, in 1973, it was hailed as a triumph of individual liberty and bodily autonomy, while others decried it as judicial overreach and moral blindness. Behind both positions were different and often unsettled answers to foundational questions. When does human life begin? What is the status of the unborn? Is the Constitution a living document involving with society, or must it be interpreted according to the framers' original intent? What Roe revealed and what its subsequent overruling in Dobbs and Jackson confirmed is that when law rules on moral controversies, it does so on back of contested premises, however carefully reasoned. This is BAZUAYE, and if you Sadola, I think I was seeing her somewhere, 2024. What is the problem here, particularly when it comes to foundations? What is clear is that even within the same legal system, judges disagree, not because of different methods, but because of the totals beneath. This is not a flaw in jurisprudence, it is its deepest reality. Law is not a machine. It is a moral and philosophical enterprise, always negotiating at times between the letter and spirit of the law. For non-lawyers, at times, when a lawyer takes a position, some may ask, are you not a lawyer? As if you have said something outlandish that is unreasonable. So judges disagree. Lawyers also disagree. You notice that Roe versus Wade was there for 50 years and was only subsequently overruled recently. But what about the issue of moral legal divide? We know of the rule that a man who merely records an accident or incident instead of helping is under no duty in tort. And this may seem cold, even absurd. But the point is that the law distinguishes between what one ought to do as a matter of morality and what one is compelled to do as a matter of legal obligation. There are some exceptions in our criminal code and penal code, and which in a way restores a limited duty to rescue within the law. But the question is, why is there no duty to rescue? The law answers, autonomy, risk, no legal causation. It is explanation after another. Just like the turtles beneath, the justifications stretch downward in search of a final ground. So the bystander that we see with our phones these days, with the phone, becomes a mirror of our jurisprudence. The law itself steps back, declining to compel, revealing that legitimacy is not always built on certainty or morality, but on a fragile layering of human judgments. In BAZUAYE and Femnigo 2016, we have the view that it is not all darkness or thick gloom. Despite the absence of a formal legal duty, the strength of moral aspirations and social norms often fills the gap. The recognition of the divide between law and morality under the no-duty rule is tempered by our sense of right and wrong, good and evil, which is expected to extend compassion where the common law withholds obligation. Validity and enforceability of customary law. BAZUAYE and INAUGURAL 2019, we have the view that enforceability and validity are distinct. Custom is not valid because a court has said. Its validity lies in the assent of the people. When a court holds that a particular customary law fails the repugnancy or public policy test, the court is effectively saying that the customary law does not fall within the description of customary laws it has authority to enforce. If we look at the Evidence Act and other statutes, you notice that the words used shall not be enforced, which refers to customary law. So this shows that it is not about validity, it's about enforcement, and that is our humble opinion. Then what about the judiciary and the foundations of Nigeria's anti-corruption struggle? We know that the judiciary plays a crucial role, particularly when it comes to corruption issues. But we also recognize the fact that there are some layering here. And the first turtle that I identified here has to do with laws and institutions. And we have formidable legislative and institutional architecture. Next, after that, we also have the judiciary. After the judiciary, we have the third turtle, independence and integrity. The fourth turtle, political will and public confidence. And the fifth turtle, civic culture and collective ethics. We argued that reform must be as layered as the turtles themselves. The lesson, to rely on a single reform, a new statute, a newly appointed judge, is to mistake a turtle for bedrock. Each layer depends upon the health of the one beneath. The fight against corruption demands that we tend them all: law, judiciary, political will, and civic virtue. Only then can we move, as we urged, beyond rhetoric and crassness toward a justice that is both real and resilient. BAZUAYE, 2016. My Vice Chancellor, this is the charge before us, to keep every layer alive and strong, lest the edifice of justice collapse under its own fragile weights. I've said so much about other areas in law, but I'm going to extend jurisprudence to another aspect of the law, which is international law. And I will start with the issue of immunity. In ancient Greeks, if messengers are ill-treated, it is not tolerated at all. It is punished. In Benin Kingdom, for example, in pre-colonial times, and also today, the Oba's messenger was not to be maltreated. The rule is encapsulated in a Benin adage, which is unaguko, meaning the error the messenger is sent cannot kill the messenger. In Ambivalence and BAZUAYE 2019, which is some form of immunity. We also have, biblically, King David of Israel, who had to go to war against King Hanun of Ammon for molesting King David's servants, who were sent to the land of the Ammonites to comfort King Hanun over the death of his father. King David had to go to war because that was the only way he could preserve the inviolability of the throne, because it was David, there is King David, who had been fictionally molested abroad. We also have a Saul, who at a point in time became vulnerable. And David, instead of taking advantage of that situation, felt that it was unthinkable that from Jehovah's standpoint, that I should do such a thing to King Saul, because he was the anointed of Jehovah. But that clearly shows that that was a kind of immunity is untouchable at that point in time. But one thing about immunity is that it is rooted in customary international law and has also found expressions in conventions. You have the 1961 Vienna Convention on Diplomatic Relations, and you have the Vienna Convention on Consular Relations of 1963. But codification has not removed its ambivalence. What codification has succeeded in doing is to systematize it. Immunity exists because the state must function, yet it also generates inequality before the law. BAZUAYE and INAUGURAL 2016. Why does immunity invite ambivalence? Like the anecdote, immunity to rest on layers of justifications: history, custom, necessity, sovereignty, and reciprocity. There is no single ultimate foundation, only a chain of interposes of state responsibility. It's entitled to functional immunity, which is otherwise also referred to as conduct-based immunity. because the officials and the state are equated one with another. BAZUAYE and INAUGURAL 2024. But even though he was alleged not to have immunity, Jack Straw, the then Home Secretary, eventually ordered that the 84-year-old on the ground of poor health, and he returned to Chile. Health concerns spared Pinochet a trial. Law had advanced a step, but on a foundation still shaped by political discretion and partial application. But what Pinochet's case showed was that international justice could, in theory, overcome sovereignty. What about federated states and sovereign immunity? The popular case here has to do with the former governor of Bayelsa State, DSP Alamesia, and he wanted to benefit from sovereign immunity when he was arrested in London for money laundering charges. So he looked up to sovereign immunity for redemption, but the court held that the Federal Republic of Nigeria and not Bayelsa State enjoyed immunity. In effect, saying only sovereign states with capacity to conduct foreign relations may sit upon those turtles. Subnational entities may carry weight at home, but internationally they lack immunity. But the point is this: no two federations are the same. It is the constitution of each federation that plays a crucial role in determining the scope of the divisibility of sovereign competencies that may exist in a federation. Like in the former Soviet Union, when they had USSR, the federating union, the states there, they had the capacity to enter into diplomatic relations, so they could enjoy sovereignty protection, as it were. But in the case of Nigeria, that is not the situation. And the Supreme Court have alluded to this. We have the cases there, Attorney General of the Federation versus the Attorney General of Abia. The two cases quite illustrate that particular position. But let's look at beyond immunities, ambivalence and legitimacy. We must be careful that immunity never harden into absence of personal accountability. It must remain chained to its purpose. And what is this purpose? Facilitating governance, not undermining justice. The challenge for Nigeria and for the international community to sustain this balance without allowing immunity to become impunity. To hold rulers accountable while respecting the stability that sovereignty demands. The ambivalence in the cases of immunity is not failure, but law's ambition to govern divided and imperfect societies. You also have jurisdiction in international law, which enables states to exercise power, authority over persons, property, and events within or connected to its territory. But like all legal foundations, they are neither absolute. That is when you talk about the various jurisdictional provisions that I will come to shortly, or uncontested. It rests on principles. Yeah. It rests on principles. And these principles are territorial principle. And when you look at the issue of territorial principle, my Vice Chancellor, beneath every legal rule lays the foundation, sometimes shaky. But one thing about jurisdiction, it is a testament to law's ambition to order human conduct within bounded spaces. It also reveals the tension laws navigate. So with, you also have the nationality principle here, and what you find with the nationality principle is that the bond between a state and its nationals remain intact. The classic case here has to do with the United States Foreign Corrupt Practices Act of 1977. And that act enables the United States to deal with its nationals who engage in corrupt practices abroad. And some of them were actually dealt with. But the irony here is that where American courts held their national accountable, Nigeria, despite being the primary site of these offenses, nobody has, in Ambivalence and BAZUAYE 2025. You have the protective principle here, which is to the effect that a state can assert jurisdiction over acts committed by foreigners outside its territory, where the acts threaten the state security of vital interests. And offenses like treason, counterfeiting, and espionage or immigration fraud are some of those things that fall under this head. But the danger here is that of overreach.